such directions. Now, one of the other issues that this court is asked to look into is whether the administrative action is rationally connected to the information before the administration. Again, as I have said, it cannot have been rationally connected to this decision when among the grounds was a law that did not exist, was issues pending before the succession court, was the exercise of freedom of expression under Article 33. I will not repeat the question about the issue, but it's one of the other issues, again, you'll be able to look at. The question of these shareholder agreements, I need not say any more about that. But is the decision unreasonable? The ungodly rush to execute a premeditated decision is unreasonable. A one-day notice to the public to conduct public participation regarding a matter that even this court has said is of great public importance is unreasonable. Conducting public participation in which the public only has access to the impeachment motion, a summary of it, by the way. The evidence was not given to the public. They were just told he has violated Article this, Section this, and Section that. Most lawyers could not tell you, with most, leave alone the public, other than my good friend Mr. Umtata. No public member can read these sections out of their head. And yet this is what they were given on this document and told, should we impeach this man or not? Passing a resolution based on public participation, as I said, that had 0% of voters who cast the votes in 2022, is unreasonable. One of the other criteria is whether the administrative action or decision is not proportionate to the interests or rights affected, and whether the impugned action or decision violated the legitimate expectations of not only the Deputy President, but the nation at large. Now, the case I cited earlier, which is the 2025 IEBC versus AG case, states the following words. Kenya's history is one of executive overreach and institutional compromise. This is what the Supreme Court said last year. And for the avoidance of doubt, Section 12 of the Fair Administrative Action Act states that the act is in addition to and not in derogation of the general principles of common law and of natural justice. Now, as I said, the National Assembly and the Senate violated all known canons of fair hearing and constitutional procedure. Amongst the most harmful things they did was to destroy almost the principle known as the principle of legitimacy. The principle of legitimacy has 3 pillars. Pillar number 1, people must have voices and their voices must count. That's the first pillar of the principle of legitimacy. The second one is that public affairs and the law must be conducted with fairness and justice. That too was violated.
And thirdly, that laws and rules must be consistent and applied evenly and predictably. I repeat, the current Deputy President is the witness of these shareholder agreements that led to the impeachment of the Deputy President seated here. The President, the Speaker of the National Assembly, the Speaker of the Senate, all are members of parties that signed and are beneficiaries of this agreement. How can we say the law is being applied equally, fairly, and evenly, even in the limited space of the political players, when one group is treated one way and one individual is treated another way? I want to rest this area of my submissions, and perhaps maybe you should allow me to just read for you, as I found my notes on the provisions of the Elections Act and the IEBC Act that deal with the question of nominating a Deputy President. These are Articles 82(1)(b), Article 88(4), the definition of the word nomination at Section 2 of the Elections Act, Section 22
of the Elections Act and Section 4D of the IEBC Act. I want to close with the following paragraph taken from the decision of the IEBC versus Attorney General 2025 case. This was a case concerning the delimitation of boundaries, and the Supreme Court of Kenya said as follows. And this is the penultimate paragraph of their judgment. However, before we conclude, we must address a matter that has troubled us. And it is my very, very tremendously humble and respectful request to this court to also be equally troubled by the things that the National Assembly and the Senate did in this matter. The history of Kenya's electoral process, from the findings of the Kriegler Commission after the 2007-2008 post-election crisis, to the litigation around elections culminating in the 2022 presidential election, reveals a consistent theme, one of a deep-seated trust deficit. I beseech this court, do not countenance any further trust deficit based on this. Leaders exercising delegated authority, such as the National Assembly and the Senate, on behalf of the people under the Constitution, rather than fueling this mistrust for short-term political gain. It appeared last year, 2024, when the impeachment was going on. It seemed that there was a deadline by 20th October. And when I slept, I woke up with a eureka moment. The idea was to have a new deficit, enhancing accountability and reinforcing public confidence in the impartiality and competence. And this is what they say. Ultimately, the legitimacy of Kenya's democratic order depends not only on credible institutions, but equally on the fidelity of political actors to the spirit of the Constitution and the sovereignty of the people, which was in question during this impeachment. Unless your ladyship and my lords have any questions for me, I want to thank you for the privilege of your time and attention. I'll rest at that point. I hand over to my senior, Mr. Swanya.
Thank you. I would like to make this comment that repeated issues are coming up in your submissions, and I want us to believe that we have had most of those issues. If you find that you are bound to repeat what has been said, we want to assure you that it is not necessary.
My name is Swanya. I'll address